Mr. Cruz.
Mr. Chief Justice, and may it please the Court. Few evolving standards of decency are more pronounced than the growing understanding in modern society of the unique and irreparable harm caused by violent child rape. From Jessica's laws to Megan's laws to the laws at issue here, elected legislatures have repeatedly acted to deter and to punish violent child rape. In particular, the legislatures of 7 states have determined that the very worst child rapists should be eligible for the most serious punishment. I'd like to begin by talking about the effect of Coker. And, Justice Kennedy, you raised in particular the dual aspects of Coker. What we would suggest the effects of Coker is that it has been under a cloud of confusion. A fair reading, a careful reading of Coker, in my judgment, it's clear Coker does not reach this instance. The Court bent over backwards to explicitly specify that it was adult rape. And indeed, the question presented in the briefing in Coker did not use the word adult rape at all. It was phrased generally in terms of rape, and the Court repeatedly, and I would suggest not accidentally, added the word adult. But that being said, the states have operated since Coker under a great deal of confusion as to what exactly Coker meant. And indeed, in 1981, the Florida Supreme Court struck down their law believing that it was, quote, compelled by Coker. And the state legislatures, when they act today, in the state of Texas, Texas is the most recent state to enact one of these laws. When the state legislature was considering it, the state legislature asked the Attorney General's office for advice specifically on whether Coker allowed that. And there's a great deal of confusion. As Petitioner argues quite passionately, those that are opposed to the death penalty for child rape argue vociferously that Coker does not allow it, as Petitioner has done in many, many pages of briefing.
You started out by saying it's the worst cases of child abuse, and that's why I was in child rape. And that's why I was interested in the definition. It seems to me this definition simply covers all instances of some kind of physical intercourse with a child, concluding oral, vaginal, anal. I can't imagine one that wouldn't be covered if the victim of this is under the age of 13. Am I right in thinking it's not the worst instances, it's every instance of rape?
You're not exactly right, Justice Breyer. The statute that is being challenged in this case was the pre-amended statute. So oral was not in it, and it wasn't 13, it was 12. So the statute that under which Patrick Kennedy was convicted was only vaginal or anal rape.
And it was not all child rape.
Exactly.
It was not all child rape. It was only children up to the age of 11.
That's exactly right. And so that was a substantial narrowing. It was 11 and younger, and it was only vaginal and anal. Beyond that, however, the juries that have considered this so far, and it has been in limited circumstances because of the distorting effect of Coker, but the juries that have considered this so far and the prosecutors that have prosecuted have shown every ability to distinguish truly egregious rapes.
But there was some indication that in most cases the prosecutors, in part to see if they can get a plea bargain, begin by saying they're going to charge with the death penalty. And I'd like you to comment on prosecutorial discretion. Again, it cuts two ways. In one sense, it's a check so that only the most egregious cases are prosecuted. On the other hand, there's a temptation to overreach, and it's an argument that the petitioners make for saying that the death penalty should not apply.
Justice Kennedy, petitioners assert that that is the case, that a plea bargain has been offered in every instance. I'm not sure the source of that assertion, but at least from the perspective of the state of Texas, we don't have information one way or the other in terms of the conduct of Louisiana prosecutors. What we can say is that the cases that have been prosecuted, the two individuals currently on death row, Patrick Kennedy and Mr. Davis, committed crimes that are just unspeakable. And in both of them, they were not children that were close to the age. They were, in this case, an 8-year-old little girl. In Patrick Kennedy's case, a 5-year-old child. They were crimes that were — and that's part of the evolving concept of decency. Part of the reason the states are acting is in modern times we're seeing crimes that 20, 30, 40 years ago people wouldn't imagine. We're seeing predators that seek out young children and do abominable things to them, and that's why legislatures are acting. I will point out Mr. Fisher speculated that if this Court made clear that Coker does not prevent a narrow statute focused at child rapists, he speculated that the states would not act. I'm standing here on behalf of 9 states. There's an additional state, Missouri, that is implicated. There's the state of Louisiana. You have 11 states. And I say, I find that speculation extremely difficult to believe.
Will you give us one sentence or two on your response to all the professionals who've come in the briefs and saying that the death penalty here will make this situation worse?
Those professionals, that is their opinion on a difficult policy question. The amici states are not here advocating that capital punishment for child rape is or isn't a terrific idea. What we are advocating is that there is an evolving understanding of the enormous, unique, irreparable harms to children, and it's elected legislatures that can sit and listen to those advocates from the groups, listen to the empirical data, consider the deterrence effects, consider all of these, and decide one way or the other. I would fully expect in time some states would act to establish capital punishment and others would not, and that's precisely how the laboratories of democracy should operate. With respect to the decisions, the prior decisions this Court has had in Atkins, in Roper, and also Tyson and Edmund, I think all of those, as the Chief Justice suggested, are about culpability. They are about saying Atkins and Roper both dealt with a class of offenders that for characteristics have limited culpability. In this instance, Patrick Kennedy is a 300-pound man who violently raped an 8-year-old girl. On any measure, he is exquisitely culpable. And the question, as this Court put it in Roper as to the Eighth Amendment inquiry for the death penalty, is whether the offender can be reliably, quote, be classified among the worst offenders. Under almost any analysis, someone who commits the sort of unspeakable crime that Patrick Kennedy commits is reliably classified among the worst offenders. I would point out a question Justice Stevens asked is, has any nation internationally gone backwards? It's interesting if you look at the history in England. England actually has gone back and forth. Blackstone actually talks about how rape under Saxon law was punishable by death, and then there was a period in 1285 where the punishment was relaxed to loss of the eyes and testicles. That was William the Conqueror's kinder, gentler version. And Blackstone describes, quote, that previous lenity being productive of the most terrible consequences, it was subsequently necessary to return to making a capital offense. And so England had that history. It is not presently a capital offense in England.
But has that sort of a different direction from evolving standards of decency occurred at all since we first announced the evolving standards of decency and jurisprudence in this country?
I am not aware of a decision doing so, but the analytical predicate for the evolving standards of decency, this Court said over and over again, the most reliable indicium is the objective judgment of elected legislatures. And in this instance, the legislatures.
But what about a comment on the international community's view that it is really a one-way ratchet?
The law lord's brief, I have to admit, personally, I found really quite astonishing. And I was hearkened back to some of the issues this Court considered in the Medellin case, because the law lord's brief argued that the United States, that this Court has no ability to determine that any other crime is subject to the death penalty. And there were two bases. One was a treaty that the United States has never ratified. And secondly was this inchoate international law understanding that because other nations have made a policy determination about the death penalty, that it is forbidden to the U.S. Congress, it is forbidden to the states of the United States, and it is forbidden to this Court to ever acknowledge there is a crime that is consistent with our Constitution. That brief, to my mind, embodied all of the dangers of the very broad arguments that were being presented in Medellin. That ultimately the Constitution and the people of this country determine what is permissible and what is lawful. This Court has chosen to look to other nations for guidance, but that brief didn't say this is guidance. That brief said the United States is foreclosed from ever doing this because other nations have made determinations under their law.
If you were asked to draft this statute, that we have here, and you have just the definition of the first statute with the what we'll call the aggravated conduct, and you had the age limit. Would any other limiting categories occur to you as being consistent with sound statutory drafting and sound policy?
Justice Kennedy, there are three possible narrowing factors that occur to me. We would submit the statute is sufficiently narrow as drafted, but beyond that, the one that has been, the four states that have most recently acted have used recidivism as a narrowing factor.
And that's prior conviction,
prior
offense, not prior offenses.
Correct. There are two other narrowing aggravators that could be applied. One would be especially heinous or vile rapes, the aggravated rape that Justice Powell discussed in his Coker opinion, a really brutal case, which both Florida and Georgia have. I would note Petitioner says Patrick Kennedy could not be convicted in any other state. In Florida and Georgia, if they concluded that his violent rape requiring surgery to correct was especially vile and heinous, he could be convicted in either of those states. Or finally, there could be, as in Lowingfield, an aggravator for multiple victims. Some of the worst of these child rapists rape more than one child, and so that is another potential aggravator that a state could choose.
Thank you, Mr. Cruz.